Hi guys, today we are returning to civil procedure. Before we start drafting summonses together, it is crucial that the concept of jurisdiction is fully understood. Therefore, jurisdiction is what we will be discussing in this episode. Before we start, please remember to hit that subscribe button and check out our social media pages. The links thereto can be found in the video description below. What do we mean by jurisdiction? Jurisdiction refers to the competence of a court to hear and determine an issue between parties. A court's jurisdiction may be limited due to the subject matter, amount in dispute, territory, and the parties. Firstly, the party instituting proceedings needs to determine whether the Magistrate's Court, High Court, Supreme Court of Appeal, which is known as the SCA, or the Constitutional Court, CC, has jurisdiction. Should the matter fall within the jurisdiction of either the Magistrate's Court or High Court, it then needs to be determined which district or division of the respective court has jurisdiction. The second inquiry is essentially a geographical one, and as there is only one SCA and CC, the Supreme Court of Appeal and Constitutional Court, the second inquiry is not applicable to these courts. Jurisdiction is so important as a court must have jurisdiction for its judgment or order to be valid, unless submission to jurisdiction is possible. If the court does not have jurisdiction, its judgment or order is a nullity. A court is obliged to raise the lack of jurisdiction mero motu, even on appeal. Take note that we will not be discussing jurisdiction insofar as criminal and labor matters are concerned, nor will we be touching on the various specialized courts and tribunals. Furthermore, the small claims court is not relevant for our discussion, but take note that the monetary cap of said court is currently 20,000 Rand, not 15,000 Rand, guys. It can also only hear claims instituted by natural persons against natural or juristic persons, and not the state. First inquiry: Magistrate's Court, High Court, Supreme Court of Appeal, or Constitutional Court? Which one? As briefly mentioned, there are two jurisdictional inquiries that are to be made when determining out of which court to institute proceedings, regardless of whether you intend to institute proceedings by application or action. The first inquiry is conducted to ascertain the type of court out of which one is to institute proceedings. For example, the Magistrate's Court, High Court, Supreme Court of Appeal, or Constitutional Court. Whereas the second inquiry is conducted to determine the exact court of the identified type, geographically speaking, to be used. If you find the aforementioned confusing, the following example should help you understand. Should we establish that the High Court has jurisdiction to adjudicate the matter, we would then need to establish which particular division of the High Court has said jurisdiction. In other words, we would need to determine whether we are to proceed, for example, out of the Cape Town High Court or the Pretoria High Court. But more on the second inquiry later. For now, let's look at the first inquiry. What determines the type of court out of which one is to institute proceedings? Firstly, the subject matter of the claim, and secondly, the amount in dispute. Subject matter. Subject matter refers to the specific kind of claim a court may hear. This is the first step to determining jurisdiction, as some courts may only hear certain types of matters. Let's take a look at what matters each type of court can and can't hear. Magistrates' courts. Magistrates' courts consist of both district and regional courts. At present, there are around 770 magistrates' courts within South Africa. District courts have no jurisdiction in matters concerning the validity or interpretation of a will or other testamentary document, in which the status of a person in respect of mental capacity is sought to be affected, in which is sought specific performance without an alternative of payment of damages, except in the rendering of an account and the delivery or transfer of property, movable or immovable, not exceeding 200,000 Rand in value, unless the parties have consented to the court's jurisdiction. But more on this later. In which is sought a decree of perpetual silence, where a divorce order is sought, where a ruling on the constitutionality of any legislation or conduct of the President is sought. Regional courts. Regional courts are subject to the same limitations as district courts, save for the fact that they may hear and determine suits relating to the nullity of a marriage or a civil union, divorce between persons, and to decide upon any question arising therefrom, and any matter concerning the recognition of Customary Marriages Act. District and regional courts have different jurisdiction regarding criminal matters, but as already mentioned herein, we will not be discussing anything criminal related. The High Court. At present, South Africa has 10 provincial high courts and 3 local high courts. The High Court, through its divisions, has inherent jurisdiction to adjudicate all matters unless specifically excluded. Special tribunals such as the Land Court and the Labour Court, for example, have been created, limiting the High Court's power to hear matters that fall within the former court's jurisdiction. Matters falling within the exclusive jurisdiction of the Constitutional Court are also excluded from the jurisdiction of the High Court. Supreme Court of Appeal. There is only one Supreme Court of Appeal in the Republic, which is situated in Bloemfontein. In terms of the Constitution, the Supreme Court of Appeal may decide any matter, except certain labour and competition matters, but is purely an appeal court, and it may decide only appeals and issues connected therewith. The SCA, or the Supreme Court of Appeal, will hear appeals from the High Court, whereas the High Court will hear appeals from the Magistrates' courts, both regional and district. A matter can of course be appealed from the Magistrates' Court to the High Court, and then appealed again to the Supreme Court of Appeal. The Supreme Court of Appeal may make an order concerning the constitutional validity of an Act of Parliament, a provincial act, or any conduct of the President, but an order of constitutional invalidity has no force unless confirmed by the Constitutional Court. Constitutional Court. Previously, the Constitutional Court was South Africa's highest court on constitutional matters only. The Constitutional Court now has jurisdiction to hear any matter if it is in the interests of justice for it to do so. The Constitutional Court is therefore not only limited to constitutional matters. The Constitutional Court is, generally speaking, the highest court on appeal in South Africa. However, there are certain matters in which the Constitutional Court will have inherent jurisdiction. In other words, the Constitutional Court will be the first and last court to hear the matter. These are disputes between organs of state in the national or provincial sphere concerning the constitutional status, powers, or functions of any of those organs of state, the constitutionality of any parliamentary or provincial bill, applications envisaged in sections 80 or 122 of the Constitution, which deal with either members of Parliament or provincial legislature applying to the court to challenge the constitutionality of an Act of Parliament or provincial legislation, the constitutionality of any amendment to the Constitution, whether Parliament or the President has failed to fulfill a constitutional obligation or certify a provincial constitution. All other matters will commence in either the Magistrates' Court, High Court, or other specialized courts and tribunals such as the Small Claims Court or the CCMA, and will only be heard by the Constitutional Court on final appeal. Amount in dispute. In addition to the subject matter of a dispute, for a court to have jurisdiction, the monetary claim or the value of the property in dispute must be within certain amounts. Therefore, once you have established which court may hear the matter based on the subject matter inquiry, you will then need to determine whether said court or courts, could be plural, may adjudicate the matter based on the amount in dispute. For example, let's say that we have ascertained that the matter does not fall within the inherent jurisdiction of the Constitutional Court, nor has it been taken on appeal. That leaves us with either the Magistrates' Court or the High Court. But how do we decide out of which court to proceed? By applying the second step of the first inquiry. That's how. What are the monetary limitations in the Magistrates' Courts? District Courts. When the amount claimed or the value of property in dispute is less than 200,000 Rand, the District Court will have jurisdiction. Regional Courts. When the amount claimed or the value of property in dispute is between 200,000 and 400,000, the Regional Court will have jurisdiction. Take note, however, that parties may consent in writing to the jurisdiction of a district court or regional court to hear matters which would otherwise be beyond their respective jurisdiction. Many contracts include such a clause. Also become familiar with the term jurisdiction cumulation. This means that if two or more claims, each based upon a different cause of action, are combined in one summons, the court shall have the same jurisdiction to decide each such claim as it would have had if each claim had formed the sole subject of a separate action. If a claim for the confirmation of an interdict or arrest granted pendente lite be joined in the same summons with a claim for relief of any other character, the court shall have the same jurisdiction to decide each such claim as it would have had if each claim had formed the sole subject of a separate action, even though all the claims arise from the same cause of action. The concept of jurisdiction cumulation is not the same as the splitting of claims. A substantive claim exceeding the jurisdiction may not be split with the object of recovering the same in more than one action if the parties to all such actions would be the same and the point at issue in all such actions would also be the same. The above differs to cumulative jurisdiction, as cumulative jurisdiction involves a splitting of claims based on different causes of action. For example, if A owes B 450,000 Rand for services rendered, B cannot split the claim into Claim 1, 225,000, and Claim 2, 225,000, to bring the amount within the regional court's jurisdiction. If, however, B was suing A for, let's say, a rear rental 150,000 Rand and holding over damages 150,000 Rand, B would have a claim for a rear rental and a separate claim for holding over damages. B would be able to proceed in the district court as each such claim is less than 200,000 Rand, despite the fact that, combined, the claims exceed said court's jurisdiction. Take note that when determining which court has jurisdiction, you are to only consider the capital amount. Interest and legal costs are not included in the determination. What happens if the claim amount exceeds the monetary cap of the district or regional court, where there has been no consent or jurisdiction accumulation? Options available to the defendants: raising a special plea or exception. Absence of jurisdiction can be raised by way of special plea if the lack of jurisdiction does not appear ex facie the plaintiff's pleadings, or by way of an exception if the lack of jurisdiction does so appear from the pleadings. Transferal of the matter from the Magistrate's Court to the High Court. The defendants may apply to the court to have the matter transferred to the High Court having jurisdiction, subject to certain requirements being met and formalities complied with. Options available to the plaintiff: abandonment of a portion of the claim. In order to bring a claim within the jurisdiction, a plaintiff may in their summons or at any time thereafter explicitly abandon part of such claim. If any part of a claim be so abandoned, it shall thereby be finally extinguished. Note, however, that if the claim is upheld in part only, the abandonment shall be deemed first to take effect upon that part of the claim which is not upheld. Deduction of admitted debt. In order to bring a claim within the court's jurisdiction, a plaintiff may, in their summons or at any time after the issue thereof, deduct from their claim, whether liquidated or unliquidated, any amount admitted by them to be due by themselves to the defendants. High Court. There is a common misconception that High Courts may only hear matters in which the amount claimed exceeds 400,000 Rand. This is untrue. The High Court has concurrent jurisdiction with the Magistrates' Courts, both district and regional. This means that a litigant may institute an action in the High Court where the amount claimed or the value of property in dispute is less than 400,000 Rand. The above was clarified in the Standard Bank of South Africa Limited and others v. Tobajane and others, and the Standard Bank of South Africa Limited v. Girana, NO, and another. This is an incredibly important case, so give it a read. Notwithstanding the above, if a claim instituted in the High Court falls within the monetary jurisdiction of a lower court, the parties may transfer the matter to the applicable lower court, provided there is mutual consent to do so. In the above scenario, and if the matter is not transferred to a lower court, the judge will very likely, when making an order for costs, award said costs on the Magistrates' Court scale. The Supreme Court of Appeal and Constitutional Court. These are appeal courts, save for the instances of direct access, and as such, there are no monetary limitations in respect thereto. So now we know which type of court to proceed out of, but there are hundreds of magistrates' courts around the country, as well as numerous divisions of the High Court. So how do we know which district, region, or division from which to proceed? Second inquiry, geographical jurisdiction. Once we have established which type of court has jurisdiction, we then need to find out which particular district, region, or division has jurisdiction. In this regard, we need to look at the court's territory as well as the parties involved in the suit. Territory. The first step in the second inquiry is to establish over what the various districts, regions, and divisions have jurisdiction. in the magistrates' courts with regards to both regional and district courts. Except where it is otherwise by law provided, the area of jurisdiction of a court shall be the district, sub-district, or area for which such court is established. Section 28, subsection 1 of the Magistrates' Courts Act provides that a magistrates' court shall have jurisdiction over only those persons set out in that subsection. Person refers to the defendants and includes both natural and juristic persons, including any divisional council, municipal council, village management board, or like authority, company incorporated or registered under any law, any body of persons corporate or unincorporated, as well as a state. Section 29, subsection 1 of the same Act provides that a magistrate's court will also have jurisdiction if the cause of action arose within its area of jurisdiction. A court in respect of causes of action shall have jurisdiction in actions in which is claimed the delivery or transfer of any property, movable or immovable, not exceeding 200,000 Rand or 400,000 Rand respectively. Actions of ejectment against the occupier of any premises or land within the district or regional division, provided that where the right of occupation of any such premises or land is in dispute between the parties, such a right does not exceed the aforementioned amounts in clear value to the occupier. Actions for the determination of a right of way, notwithstanding provisions of Section 46. Actions on or arising out of a liquid document or a mortgage bond, where the claim does not exceed the maximum prescribed amounts. Actions on or arising out of any credit agreement as defined in Section 1 of the National Credit Act. Actions in terms of Section 16, subsection 1 of the Matrimonial Property Act, where the claim or the value of the property in dispute does not exceed the prescribed amounts. Actions including an application for liquidation in terms of the Closed Corporations Act. Actions other than those already mentioned in this section, where the claim or the value of the matter in dispute does not exceed the prescribed amounts. A court for a regional division in respect of causes of action shall, subject to Section 28, subsection 1a, have jurisdiction to hear and determine suits relating to the nullity of a marriage or a civil union, and relating to divorce between persons, and to decide upon any question arising therefrom, and to hear any matter and grant any order provided for in terms of the Recognition of Customary Marriages Act. So these kind of matters may not be heard in a district court. The court may also order attachment of property to found or confirmed jurisdiction against any person who does not reside in the Republic, in respect of an action within its jurisdiction, where the claim or the value of the matter in dispute amounts to at least 2,500 Rand, exclusive of any costs in respect of the recovery thereof, and may grant an order allowing service of any process in such action to be effected in such manner as may be stated in such order. High Court. Section 21, subsection 1 of the Superior Courts Act states that divisions of the High Court have jurisdiction over all persons residing or being in, and in relation to all causes arising and all offences triable within, their areas of jurisdiction, and all other matters of which they may, according to law, take cognizance, and have the power to hear and determine appeals from the magistrates' court within their areas of jurisdiction, to review the proceedings of all such courts, in their discretion and at the instance of any interested person, to inquire into and determine any existing, future, or contingent right or obligation, notwithstanding that such person cannot claim any relief consequential upon the determination. Section 21, subsection 2 states that jurisdiction can also be acquired over a person who doesn't reside in the court's area of jurisdiction, if that person is joined as a party to any cause in respect of which that court has jurisdiction, or who in terms of a third-party notice becomes a party to such a cause, provided they reside or are within the area of jurisdiction of any other court. Section 21, subsection 3 states that any division may issue an order for the attachment of property to confirm jurisdiction, subject to the compliance with certain other legislative provisions. In terms of the common law, where property forms the subject matter of the legal proceedings, a plaintiff must institute said proceedings in the court in the area where the property is geographically situated. Examples of instances where this jurisdictional ground would apply include, inter alia, claims for ownership or possession of immovable property, claims for the ejectment of occupiers of property, claims involving the transfer of immovable property, and delivery of movable property. The common law also confirms that a division will have jurisdiction if the cause of action arose within its area of jurisdiction. There are two types of causes of action, namely contractual. The cause of action can arise where the contract was concluded, where the contract is to be performed in whole or in part, or where the contract was breached. If any of the aforementioned arise within a court's area, said court will have jurisdiction. Should, for example, the contract be concluded in jurisdiction A, but be breached in jurisdiction B, the plaintiff may elect out of which of the two courts it wishes to proceed. This is due to the principle of convenience. Delictual. Usually, a wrongful act and the resultant damages occur simultaneously. Therefore, the court in the area of jurisdiction of which the wrongful act took place will have jurisdiction. To summarize, the area of jurisdiction of a particular division of the High Court shall be in respect of persons, in other words, defendants, residing or being in the division's area of jurisdiction, claims in which the cause of action arose within a division's jurisdiction, and where movable or immovable property is situated. Parties. The final step only applies when jurisdiction is sought to be founded based on the defendants being within the court's area of jurisdiction. The word being is not enough. There are various rules that apply to the consideration of persons being within a court's jurisdiction. Magistrates' courts, both district and regional courts. Section 28 of the Magistrates' Courts Act provides that a court will have jurisdiction over the defendants or the respondents of the matters in application if, within the court's area of jurisdiction, the defendant is resident, the defendant carries on business, the defendant is employed, the defendant is a partnership and has its business premises situated or any member whereof resides, the proceedings are incidental in nature, the defendant does not necessarily reside but does not object to the jurisdiction of the court, and the defendant owns immovable property in actions in respect of such property or the mortgage bonds thereon. Defendants who are residents in the court's area of jurisdiction. A person does not reside at a premises or place which they are only visiting temporarily. The person in question would need to consider the place to be one of their homes, at least for the time being. A person may have more than one residence. The court which will have jurisdiction is that in respect of the area that the defendant is resident at the time the summons is served. A company only resides at its registered office or principal place of business. It could be argued that the residence of the state is Pretoria or Tshwane. Very important, there is a difference between residence and domicilium. Domicile is acquired by establishing residence at a place with the intention of remaining there permanently. Another important thing to note is that domicilium is not a ground of jurisdiction on its own. It must be established that the person is resident or employed or carries on business, for example, at said domicilium. Alternatively, where the defendant is a juristic person, the domicilium must also be their principal place of business or registered address or any of the other jurisdictional grounds. Domicilium clauses are found in almost all contracts. Do not allege in the summons that the court has jurisdiction to hear a matter due to the defendant being domiciled within the court's area of jurisdiction. Make reference to their residence or registered office or principal place of business, etc. Defendants who carry on business within the court's area of jurisdiction. What constitutes carrying on business is not clearly defined. From case law, it seems as though a person carries on business at a place if there's some regularity in conducting affairs at said place, usually but not necessarily for profit. Whether the defendant is a firm or sole proprietorship, the business being carried on must be owned by the person who is the real defendant. For example, whether the defendant is a sole proprietor cited as James Smart trading as James Mechanics, the defendant may be sued where he is resident as well as where he carries on business. Defendants who are employed within the court's area of jurisdiction. There must be a degree of permanence to the defendant's employment. The defendant may not be sued where their employment is only temporary. The defendant is a partnership and has its business premises situated or any member whereof resides in the district or regional division. If a partnership's principal place of business is located within the jurisdiction of a specific court, this should be sufficient to confer jurisdiction on that court. Where the proceedings are incidental in nature. What are incidental proceedings? The word incidental means arising out of the same facts. Obvious incidental proceedings include an application to set aside a judgment or an application for leave to sue. A counterclaim is also incidental in nature. For example, A sues B, B delivers his plea together with the counterclaim for damages arising out of an assault committed against him by A. The assault happened outside the jurisdiction of the court. However, if the counterclaim is incidental to A's claim against B, then the court will have jurisdiction. Therefore, a defendant may not, in a counterclaim, sue a plaintiff in the present court if it does not have jurisdiction where the counterclaim is unrelated to the main claim. Where the defendant does not necessarily reside, but does not object to the jurisdiction of the court. By entering an appearance to defend does not mean that a defendant consents to the jurisdiction of the court. the defendant will need to raise lack of jurisdiction in their special plea. A defendant who fails to object to the court's jurisdiction may be taken to have consented to the jurisdiction of the court only in respect of his or her person. The defendant cannot consent to the jurisdiction of a court which lacks jurisdiction in respect to the size of the claim or the nature of the matter. Remember, as already stated, the magistrate must raise lack of jurisdiction. Where the defendant owns immovable property within the district or regional division, in actions in respect of such property or the mortgage bonds thereon. If a plaintiff wants to rely on this ground for jurisdiction, an averment must be made to this effect in his or her particulars of claim or founding affidavit, depending if it's an action or an application. Exceptions. In terms of Section 2, subsection 1 of the Divorce Act, a court shall have jurisdiction in a divorce action if both parties are, or either party is domiciled in the court's area of jurisdiction on the date when the action is instituted, or ordinarily resident within the court's area of jurisdiction on the date on which the action is instituted and has been ordinarily resident in South Africa for 1 year immediately prior to that date. Therefore, in divorce proceedings, a court can still have jurisdiction where, for example, the plaintiff is domiciled and ordinary resident within its area of jurisdiction, despite the defendant being domiciled elsewhere. In interpleader proceedings, the court will have jurisdiction if the execution creditor and every claimant to the subject matter of the proceedings reside, carry on business, or are employed within the district or regional division, or the subject matter of the proceedings has been attached by process of the court, or such proceedings are taken under Section 69, subsection 2, and the person therein referred to as the third party resides, carries on business, or is employed within the district or regional division, or all the parties consent to the jurisdiction of the court. There are further specific jurisdictional exceptions, but to take you through each one would be impossible. High courts. Almost all of the above jurisdictional provisions apply to the High Court as well. Take note, however, of the following. Section 21, subsection 1 of the Superior Courts Act states that divisions of the High Court have jurisdiction, inter alia, over all persons residing or being in their areas of jurisdiction. So what does this mean? Natural persons. This means the defendant's residence. We have already explained what is meant by a natural person's residence. Corporations. A domestic corporation is both resident at its principal place of business and registered address. Take note that there is a difference between principal place of business and merely a place of business. Think about a franchise, for example. It will have many places of business, but that does not simply mean you can serve on any of the franchises around the country. The principal place of business has often been expressed as the place where the direction of the company takes place. Partnerships. The same principles that apply to determining a court's jurisdiction with regards to partnerships in the magistrate's courts also applies to that of the High Court. State, as already mentioned, the state can be considered to reside in Tshwane or Pretoria. Where immovable property is situated, the same principles also apply here. There are also various jurisdictional exceptions in the High Court, which also includes Section 2.1 of the Divorce Act and so on. To conclude, determining jurisdiction requires a two-step inquiry. The first inquiry involves looking at which type of court has jurisdiction. This is determined by considering the subject matter of the claim and the amount in dispute. Once a type of court has been established, one then needs to proceed with the geographical inquiry to ascertain which particular division, district, or region has jurisdiction. This inquiry does not apply to the Supreme Court of Appeal or the Constitutional Court due to there only being one of each court. The second inquiry looks at the territory of the various divisions, districts, or regions, as well as who the parties are to the matter. Take note that this is not a universal procedure for determining jurisdiction. However, if you're uncertain as to which court has jurisdiction, follow this approach. Please, if you enjoyed this video, hit that subscribe button and share this channel with your friends. We're also on Facebook and Twitter, so give us a follow there too. The links are in the description. Our website is currently under construction as well. Also, if you have any episode ideas, let's hear them. Ciao.